We're now recording this meeting, and I will begin by taking roll. We don't formally have a chair for this group, so I will begin by taking roll. Be sure to unmute yourself when I call your name and let me know that you're here. Bashan?
Here.
Hamilton?
Present.
McRae?
Here.
Olvera?
Here.
Sarush? Did not see Fariba. Okay, so the purpose of this group is to use what we were referring to as the wobbler process for the family, children, and custody practice area. And so what we're going to do is present information from the Justice Gap study, from the California Attorney Practice Analysis, and some other information. And I just see that Fariba has joined us. So Fariba, I'm just calling roll. So I'm gonna call your name, Sarush. If you can unmute and indicate your presence.
I'm here. Hello, everyone.
Hi, thank you. Hold on 1 minute. So I'm going to go ahead and let, well, first of all, I think we need to take public comment. So if there's anyone who wants to make a comment, then please raise your hand and then I will unmute you. Is there any member of the public who's here who would like to make a comment before we get started? Okay, and I see that Leah Wilson has joined us now. I don't know if you wanted to make any introductory comments, Leah.
No, I don't think so. You could go ahead.
Okay. So we've taken roll, and Araya is going to present the PowerPoint presentation and get the conversation going.
Thank you, Linda. Hi, everyone. So I'm going to go ahead and start the presentation, and please feel free to stop me if I'm going too quickly with the slides. They should be self-explanatory, but so we're going to go ahead and start. As Linda just briefly mentioned, we conducted a Justice Gap study, and in this study, there was questions asked in regarding to family. And as you can see on the screen, some of the questions asked about problems with serving as foster parent, issues adopting a child, difficulties with being appointed as the guardian of a child, filing for divorce or separation, difficulty collecting alimony payments, experience with domestic violence or sexual assault, and problems involving a vulnerable adult being taken advantage of or abused. And these questions were asked of all respondents. The other questions that were asked were in regards to child in custody. And these questions asked about trouble reaching an agreement about custody or visitation arrangements, a custody or visitation agreement not being followed, problems collecting or paying child support, issues with age eligibility for foster care, paternity problems, investigation by Child Protective Services, an attempt by CPS to terminate parental rights, and involvement in a court hearing involving dependency of a child. And once again, these questions were also asked of those with a parent, with parent or guardian in their household. And so as the result of the Justice Gap study findings were that the top 3 areas where legal help sought and received, all Californians, were in wills in the state, children in custody, and family. And top 3 areas having a substantial impact for those less than 125% of the federal poverty limit was children in custody, veterans issues, income and maintenance. And the family law issues, particularly, were adoption, dissolution, spousal support, as you can see, children's support, domestic violence, elder abuse, and possibly civil harassment. I know that we discussed that in the previous meeting, but we just included this as part of the discussion for today to see if this should also be included under family law. As for children in custody issues, is the custody and visitation, child support payments, paternity, child protective services investigation, dependency and termination of parental rights, guardianship, aging out of foster care to be considered. And the judicial branch statistical information shows this for pro-per family law litigants. And as you can see, since
So this is the GIBSIS data. We're providing this just to give you some additional data points. And this data is going to be focused on pro-per litigants in family law. But this is the data we got from Bonnie Huff at the Judicial Council, the GIBSIS data. Go ahead.
That is correct. And as you can see from this chart, since 2008, the percentage has increased, steadily increased, with except for 2016, between 2015 and 2017, where it went down slightly, but it remains steady. And when it came to the self-help centers, the 2018-2019 client encounters, the case types reported were for 490,552 encounters, were 80% family law, and of that, 34% with dissolution, 31% child and spousal support, 28% pertain to child custody and visitation, 6% was for domestic violence, 5% for parentage, and 8% other family law. And the California Attorney Practice Analysis Study showed that, which is the CAPA subtopics, that under family was division of property, support, adoption, custody, including dependency, domestic partnership, marriage, and dissolution. And under estate planning, trust and probate was conservatorship and guardianship. And the modified composite rating for legal topics under family law, as you can see, is the two highlighted is the family law and the estate planning, trust and probate.
But just a quick reminder, this is the California Attorney job analysis done to ultimately potentially form the basis of a new bar exam. And this composite score takes into account both the frequency of the topic area and the criticality rating that survey respondents afforded. And they were doing these criticality ratings at the subtopic level, so that the previous slide showed the subtopics under family law and under estates and planning. So the respondents rated them at that level. So you can see family law is sort of above the midpoint, estate planning, trust and probate below in terms of that composite frequency criticality score.
And the next slide is also related to, is about in regards to the depth of knowledge by legal topics. Leah, did you want to speak to this?
So this is the depth of knowledge required. You can see constitutional law is at the top and professional responsibility at the bottom, although the range here is not very big. So we just give this to you as an additional data point, not frequency, not criticality, but what level of knowledge do you need to have in order to perform the various tasks that attorneys were performing when they completed the CAPA survey. And this gives you the depth of knowledge respective ratings.
Thank you. And the California Association of Legal Document Assistance Survey, also known as CALDA, information shows the question was, how many clients do you serve each year? And as from the chart, the average number was, their responses received was 78, and all the total respondents, 78, and total numbers of 5,625. I'm going to leave this in for a second. And then also from the CalDA survey, the second question was, how many years have you been in business? And over 50% had been more than 10 years. And the question 3 asks areas that you provide. LDA services are, as you can see, family law was the highest, had the highest percentage at 77.22%, closely followed by probate and estate planning, and real estate deeds and business information. So in somewhat the conclusion of the slides, the subcommittees needed to recommend subtopics and tasks. Our thought was that we would need for dissolution, custody, adoption, child support, guardianship, conservatorship, dependency, domestic violence, elder abuse, and civil harassment. And with that, I would like to open up the conversation to see, to get your thoughts and see how you wanted to proceed with that, and as to assign subcommittees or how we should proceed with tackling all these subtopics.
I'm trying to start. Oh, you're still sharing the screen. Stephen Hamilton here. So I think I would start on the topical area first. Is there going to be any area of family law that we are going to say a paraprofessional shouldn't be offering advice on? Most of the, I mean, there's no limitation on what documents an LDA can prepare within the wide spectrum of family law issues that come up. And I think, Elizabeth, that's correct, right?
Correct.
Yeah, so an individual LDA may say, look, that's beyond my expertise and you should go talk to a lawyer, but there's nothing that stops you from doing a marital settlement agreement that divides a $100 million community estate, correct?
Correct. There's, we use software prepared by attorneys. And yes, we create those documents based on the terms that the improper litigants give us. Yes,
yeah.
We just type it up.
So I think we start off with the premise that we're not going to create for the paraprofessionals a restrictions that doesn't exist for the LDAs. They're going to be able to prepare any documents that an LDA can. I'm trying to get my video unstopped, although I look probably better on my picture.
Yeah, I am too. It's saying, Linda, that you need to allow us to share our videos.
I wonder what, I can't quite figure out how
Okay.
the technology.
What I did, it was actually a suggestion of one of the
There we go.
attendees who's on the Family Law Executive Committee, is looked at the specialization examination list for family law to get an idea of would there be certain areas where we would say a paraprofessional shouldn't be offering that advice. For example, can I share my screen?
You should be able to, I believe.
Okay.
I have stopped sharing.
Okay, let me see. I gotta make sure I don't share the wrong thing. Where is it? Okay. So this is I excerpted it from the specialization. These are the different areas that you can be tested on as a specialist. And I think it's good for us maybe to carve out areas where the paraprofessional shouldn't be giving advice. This one was a no-brainer to me. Even I don't give advice to my clients on taxes. I refer them to the accountant. So I think if they're going to be offering legal advice, this probably should be an area that they should not be advising on in terms of support recapture rules and the tax liability issues that may be associated with the division of property. These areas right here, 1 and 2, are procedural in nature. We wouldn't have those within the parameters. I think that all of these are fair game because the LDAs are already doing agreements about that they are dealing with fiduciary duties because they're helping people fill out their declarations of disclosure. They're dealing with the division of assets and debts because they're generating marital settlement agreements. So empowering a paraprofessional to offer a legal opinion about that, assuming that we've got comparable training and education requirements similar to Arizona and Washington, I don't see this. This is probably going to be a fair game to do. On the area of children, I think that's when we should talk about. I think support factors, I think that's all going to be probably to narrow it out. Because of DCSS being involved in cases, I don't know that we would restrict a paraprofessional from helping a parent, because typically DCSS is supposed to be neutral in the case, and they're not necessarily developing evidence or theories that a parent should be producing or addressing in a DCSS monitored case. Elizabeth, do you ever do Marvin lawsuits?
No, we refer those out to mediators.
Okay.
Or attorneys.
Yeah, I'm going to say probably take out. Do you ever do cohabitation agreements?
No, those are also referred out.
Yeah. So I'm thinking that's probably an area not to include, especially because even within family law, when you get into the Marvin lawsuits, I just got one today from an attorney in a case because there was a premarital relationship and it was poorly drafted. And this is such a hybrid area of law that it's not even exclusively family law because it involves civil tort theories. I think that one's probably one to discuss how big the scope should be. Procedure really isn't, again, an area we do. I think we have to talk about, I'll try to get this to do this one. Are we going to have paraprofessionals negotiating with attorneys in cases? Are they going to participate in arbitration or private judging? Should they be allowed to participate in mediation? And should they be able to represent a party in a collaborative action? And I'm highlighting the ones I think that are the ones that require discussion, the wobbler areas for family law. Number 10 is this, so this part of it. 10 comes up in the area of custody and visitation in terms of how do you advocate or argue for issues there. I don't know that that's going to be subsumed within the custody hearing because you may get an order in a custody case that a parent has to test. But this was what kind of was, again, a good suggestion that I got when I was meeting with some of the family law section attorneys about a good starting point to identify particular areas. Elizabeth, if you've got a high net worth case and the person needs advice, technically you can't give it to them, correct?
Right, we don't give legal advice.
Do you think that we do deal with something in terms of, is there a monetary limit on the types of cases a paraprofessional should be able to give advice on?
My opinion is no, given that we're in the Bay Area and there's a lot of high-end clients and there really isn't a need to limit it.
What do you do? Do you have malpractice insurance?
I'm a legal document preparer. I don't have that malpractice insurance. When I do work under the supervision of attorneys, we're covered under their plan. They just have to disclose that they have independent contractors.
Yeah. So I guess that's the thing where I get into the tricky area. Is there some kind of monetary limit on the types of cases that paraprofessionals should be able to offer an opinion on? And if so, because the issue is going to be, if an attorney doesn't have malpractice insurance, they have to put that in their retainer agreement to their client. And we're going to have to address that when we get to a different part of the discussion for the paraprofessional program.
And then a lot of the clients that come to us, they don't have high assets. They're low income. They make too much money to get free help from the court access center. but they don't make enough money to be able to hire an attorney. So I don't see that as being like there's going to be some outliers. Of course, there are some people who come to us and they just don't want to pay attorney's fees. It's not that they can't afford it. They just don't want to because they know that they can get great service. And so, yeah, I just wanted to make that point that I think that that's an outlier case as opposed to the norm.
Leah, do we know, we haven't got to that part of the discussion yet, but I'm assuming there's going to be a similar requirement for disclosure if you don't have malpractice coverage, right? As a paraprofessional.
Right. Well, you all will be coming up with those requirements when you move to the licensing and regulation portion of your. So I think you'll have plenty of, latitude to set the requirements for both coverage and disclosure as you see fit.
Yeah. What I'm thinking, so the cases that you're talking about, Elizabeth, like, I think we have to contemplate whether there should be a monetary limit on the size of the marital estate to be divided. In other words, if either party puts on the schedule of assets and debts that the net assets are worth more than $1 million or more than 500,000, should a paraprofessional be giving legal advice in that situation? Because once we know that either party says that that's what the estate is, then maybe we're creating a situation where a paraprofessional could create a problem that can't be fixed. Specifically, malpractice is committed and the policies for the paraprofessionals probably are going to have smaller limits. And there's not going to be a big enough policy or enough assets of that paraprofessional to cover the loss. And we set the threshold high enough where it's not catching those cases that you're already working on, Elizabeth. What's the biggest, again, you got to kind of look at what the net estate is. Are you dealing with preparing agreements in cases where the cumulative value of the assets is more than $1 million?
So I don't make it a habit of talking about my clients and the details of their cases. But a lot of the clients that do have high assets, they know that they can get consultations from attorneys for that legal advice aspect. Again, as legal document preparers, we refer them out for them to make their decisions. However, they are able to come up with their own decisions. I mean, they're smart people. That's why they have a high net worth. So they usually don't rely on us to tell them how to split their assets. And we're able to point them to published legal information that tells them, absent them coming to an agreement, what would be the law on this certain topic. And they can always consult with attorneys, but we refer to the law.
So I'm gonna jump in because I think we're kind of getting into the weeds, and I want to step back and hear from others in the working group. So Araya provided a list. There's a long list of topics that are included in family and child in custody from the Justice Gap study. Then there's also this question of whether or not civil harassment should be brought in. I think we were a little unclear how you all left that at the last meeting. I think what you've been focused on looking at the specialization categories is, if I have it correctly, it covers dissolution, it covers support, and it covers custody. But there are a lot of other topics potentially under family and child in custody. So one question is, how does this group want to tackle all these different topics? If your suggestion is we just start with dissolution, custody, and support, then that's certainly one approach. But I want the group to weigh in, recalling that we have now in here conservatorship, guardianship, we've got dependency, we have all of this other stuff that we need to tackle. So I'd like to just step back for a moment and see, looking at this body of work that needs to be tackled, how you all want to do that. And Araya, maybe you can put up that last slide again, just so quickly we can see it.
I will do that.
And correct me if I'm wrong, Stephen, if the specialization covered more than dissolution, support, and custody.
Oh, it does. It was all of those topics that I had on the screen. I was skipping over custody and visitation because I'm assuming that paraprofessionals are going to be assisting people in those areas. That's one of the high need areas. That's what drives those self-represented statistics that you got from Bonnie Huff. I mean, I'm in family court every day and I see how many self-represented parties are that could benefit from getting advice from someone in preparation of their paperwork. And with the current structure of both for restriction on paralegals as well as the restriction on LDAs, they need to be getting advice on how to prepare exhibits, what arguments to make in court. I'm assuming that that's included. That's what I'm saying, Lee. It's not. Custody and visitation is going to be an area that paraprofessionals are going to be able to provide services and to give full legal advice to people in those areas of law. I'm starting with that as a premise.
I'm sorry, if I can interrupt for just a moment. We don't really have a chair for this group, and I see that a couple of members of this subgroup have their hands raised, and I'm not sure what the protocols are that we want to use for people to speak, if people want to just speak up, or if we should have someone call on people when they want to speak.
Why don't you go ahead and call on people?
Okay, so Fariba you've had your hand up for a few minutes.
Thank you. So first off, I think a list like the one Steve provided would be great guidance. That is an exhaustive list of issues that may pop up in any case, and then we could take, and it provides guidance for discussion. You know, should it be included, should it be not included, and then consider pros and cons. I wanted to address the comment about we're not going to ask more of paraprofessional than paraprofessionals in this new program that's imposed on just any paralegal LDA out in the community. And I would respectfully disagree. I think for the privilege of earning a permit or a license or whatever we call it to become a licensed paraprofessional, you've got to meet certain criteria, and whatever criteria we come up with, it could be different from what any unlicensed paralegal or LDA could do out on their own. But if they want to become a paraprofessional under this program, they've got to meet certain requirements, and they can do this, but they cannot do this. And this could be independent, an independent list, and that's garners trust in the public that if I hire somebody who's a licensed paraprofessional, I can trust on X, Y, and Z, including that they will not be doing this because, you know, they've been deemed not to be able to do that because it's legal advice. One clear example to me, and it's my opinion, that's how I function in my office, we don't create MSAs from pleadings. We use judicial counsel forms because there's so many opportunities to go wrong. If you miss a paragraph, you miss something, then, you know, that it could really harm the person who was relying on effectiveness of a certain paragraph, right? So we don't really engage in that. My apologies. I have more comments, but I just wanted to respect what Leah said with regards to we don't want to get into the weeds. And I think we really got to decide how we're going to approach the discussion. I think the list is really great idea. Right there, the list that Steve provided right there, it really focused me. And it may help focus our discussion and just go one by one through and decide. I had previously suggested that we group the violence prevention orders into one because they do share certain characteristics from a discussion standpoint. And I leave that to the group to decide. And I just wanted to make one last comment about smart people. I think that we're all smart, but I'm a smart lawyer, but I'm not a smart doctor. So I cannot learn to, operate on myself. So I get really smart people here in the Silicon Valley who are fantastic at what they do, no idea about these things. And I think that makes sense, right? You're really good at what you do, but you can't be good at everything, even if you read 100 articles on Google about it. And I think that's where you really got to have professionals who know what they're doing, drafting that MSA, for example, stock options, things like that. We don't even touch that stuff here. Even though I have the knowledge, I just cannot expect my staff to handle, something for someone who makes, I don't know, $1 million a year. And we're not going to do that. Just the crossover issues that are created because you make a lot of money means they need legal advice and strategizing. That requires a lot of experience. And I think even new attorneys got to be careful. I teach law, and one of the professional responsibility part of what I teach is all about that just because you have a license to practice law doesn't mean that you should take every case. You've got to have that knowledge, otherwise you'd be committing malpractice. And my final point is, yes, I would recommend that we do require some sort of malpractice insurance with this new group of professionals that are going to be licensed. And I don't know if any discussion has started with the insurance companies.
And it
That's
looks
it.
like,
Thank you.
okay. And I think Dana also had her hand up.
Thank you.
Comments.
I'm looking at the list that's currently on the screen. I'm wondering if anybody like me has strong opinions about a topic that should be removed from consideration. And maybe that's a way to get this list pared down.
I think conservatorship should come out.
Dependency.
Agreed. I completely agree that dependency is not appropriate.
Agreed too.
I agree.
Okay.
Actually, there are some needs in conservatorship for paraprofessionals. I would recommend, I don't know if it belongs in this subcommittee, but we help a lot of people here at the Self-Help Center with conservatorships, limited conservatorships. We actually have a workshop and it's full, and we have a 4-month backlog on that. So I think that there's a need, whether it belongs in this group or some other group.
Let me clarify. So conservatorships of the person, yes. Conservatorships of the estates, no.
Yeah, thank you. Limited conservatorship and conservatorship of the person, absolutely.
And Freeba, do you think it should stay here? Because it does kind of fall into that guardianship area that we're going to subsume within the family law discussion. I mean, kicking it out to the civil committee doesn't really make sense.
I do agree that you may not have a group in which this fits perfectly. It doesn't involve custody visitation issues, support, and like there's no a common thread between like a guardianship involves a child. The guardianship of the minor child involves custody visitation issues, and they go to mediation and family court services, at least in our county. So they do share certain characteristics. Family conservatorships don't. But again, we may want to keep it because it just doesn't belong anywhere else either, and we're the best people to handle it.
And because it was included in the justice gap study, at least in the questions for family and child in custody, it included conservatorships. So is there any, I appreciate your question, Dana. And I'm wondering if we want to do grouping. Fariba, you recommended violence prevention. So that would be DV, elder abuse, civil harassment as a group. Dissolution, custody, child support are an obvious grouping to me. I don't know about if adoption fits in with that group, or where you all see adoption, and do adoption and guardianship go together? So just thinking about group.
I wouldn't put custody and visitation with dissolution. Could be an unmarried couple. It's a very simple divorce, or it could be a paternity action where the parties don't have a custody dispute. I would actually change dissolution to dissolution of paternity, meaning they're trying to get a judgment in that case. And then I would segregate out some of the issues that can come up, like segregate out division of assets and debts, segregate out custody and visitation, the abuse category, like you mentioned, and then protection of the person that doesn't involve abuse, where you could do the guardianships, the conservatorships, and the adoptions.
What do others think about that? Protection of the person, but not a violence prevention. So we have a violence prevention group, those last 3 bullets.
Yeah.
We have dissolution and paternity, I think is what you said. And then that's separate from division of assets and debts. Did I understand that correctly?
Correct, and separate from custody and visitation.
And there will be crossovers. I mean, parentage issues will always have a custody visitation issue in it. I mean, that's why they open it, right? Along with if there's any competing presumptions or something like that. We will have crossover issues, but I kind of like categorizing them that way and removing dependency, right?
Yeah.
So
Yeah, I think that this is probably as clean as it's going to get, and I like it.
Okay, so Orion, do you have the ability to kind of work on modifying a slide? Maybe.
Yeah, let me see if I can do that in edit mode.
Okay, and then I just want to remember that there was also, separate from dependency, there was a CPS investigation. I sent you a private note, Orion, because I didn't know where that bullet went. There was one of these elements from the Justice Gap study was a CPS investigation, as separate from termination of parental rights. So I just didn't want to lose that. Remember, we talked about how in dependency, the right to counsel, there is a right to counsel, court-appointed counsel, but not simply because there has been a CPS claim filed. There's no right to counsel in those circumstances. So I just want to throw that out there. I think this often, if it happens, it's happening in a contested custody situation. That's where I've seen it happen.
So you're talking about cases where CPS is not going to refer it to the juvenile dependency court, but they're, opening an investigation to say,
yeah, it's scary to the parents, and what are we going to do? And often parents will, make claims against each other, and what do you do? So it was in the Justice Gap category, but I don't know, it didn't make it onto this slide. But I didn't want to lose it, and it may be something that you all deal with when you talk about custody, as something that they may do. They may help deal with a CPS complaint, the paraprofessional.
So typically what they're going to do in that case is they're going to issue a safety, if they're not taking jurisdiction over their child, they're going to do a safety plan. And if the parents don't comply with the safety plan, then it becomes a dependency case. And the safety plan, if there's a custody issue in the case, if there is a dispute between the parents, the safety plan is going to come up within the scope of the custody and visitation. I guess the issue would be is if there's a safety plan that's in place between an intact couple that doesn't have a custody case. Wow.
What happens in our county is they're told, oh, I'm sorry, Stephen.
No, go ahead, I'm sorry. I went free flowing.
What happened in our county is CPS workers are told, because of budget cuts, for example, we have to open 20% fewer cases, right? So that threshold of for opening cases goes up, right? The level of abuse or whatever they're seeing goes up. The rest of those people are told to come to family court and open a case. And we see those people, right? Open an emergency, file an emergency or something. So what I'm thinking is that the paraprofessionals could help with how to get, for example, the report from CPS, how to communicate with the social worker at CPS, and how to get the best information possible for their client to either file an emergency or oppose one or respond to one. So maybe that's how it came up.
Yeah, so maybe I think for now, I just don't want to lose it because we lost on this slide. For the custody discussion, I think it can come back in.
So I just wanted to, if you can take a moment and see if I had it grouping correctly.
I think it should be dissolution and parentage.
Yes.
But didn't they say that parentage just was very minor? I mean, only 6% of those cases are in the court system. I don't see why we would really separate that and give it that much attention if it's very limited to how many people are actually coming in that are unmarried and have parentage issues.
Where did that statistic come from? Because we see a lot of those cases.
Yeah, I would agree with Fariba on that one. And it's mainly about getting them a judgment. There's so many times where DCSS will start the case for the support issues. But if they're not getting public assistance, then you don't ever get a parentage judgment, which could have pretty far-reaching impact, like for a child that's never been formally recognized as the parent of the non-birth parent, or the child of the non-birth parent.
Yeah, parentage cases are like divorces for unmarried parents. So it's the main vehicle through which to get a custody order and child support order.
That's why I'm saying, why don't we just leave it under the big dissolution umbrella? Why?
Because it's
separate
for
it?
unmarried parents.
But it's still family law, parents, children. Where the only difference is they're not married.
Yeah.
But I think
That's just my
Elizabeth,
thought.
for now, it's just creating some categories. You all may, once you get into it, decide, you know, you don't want to include parentage at all. But this is just grouping our work. So we see, like, let's pare down this long list into some groups.
Sounds good.
Yeah, dissolution and parentage. Under that, Araya, we have division of assets and debts. No, underneath, a separate bullet.
Oh, okay.
Thank you, Leah.
Spousal support needs to go in there somewhere.
Yeah,
Okay.
support, I do support, and then it'd be, the subcategories would be child and spousal.
Custody and visitation.
Custody and visitation.
Yeah.
Right.
All right. Does this look like our list?
Double checking.
May I just say a word about adoption? Not to go backwards, sorry, but, you know, public adoptions happen in dependency court, and adoptive parents are, I believe, well cared for in that context. So can we say private adoption under protection of the person?
But what do you, like, I did a step parent adoption 100 years ago, and that it was investigated by the social services agency. So even though it was private, I think it would be private, but there was a government actor involved in doing like a home study and making a recommendation.
That's right. That's right. You have to, in the private adoptions, they're still going to do the because my private clients that I've done it for, they've had to pay the fee.
So do you mean a step parent you just mean not an adoption that's not rising out of foster care?
Adoption that's not rising out of a dependency matter, yes.
Yeah.
Where
Adult adoptions too.
So maybe Araya put in parens after adoption, just so we know what we're talking about, not arising out of a dependency matter.
thank you.
Is that good?
Yeah.
Does this list look accurate? And I left this here so that we knew that that was there, but we're striking it. But I'll go ahead and remove it now. Does this look accurate?
I'm checking.
Did we decide to keep in guardianship?
I think it's not excluded yet. You all may. I think it was actually explicitly added the last meeting.
Okay.
Meaning added for you all to consider. You may consider it and decide you don't want to include it. So if this list looks accurate, I think the next question is, do you want to tackle each of these groups as a group in the entirety, and do you want to do them in the order presented on the screen or a different order? Do you want to create some subcommittees to work on some of these groups? And I think regardless of what we do, using the specialization frame, Stephen, is a great idea. We'll steal that for all of these working groups. As a way to kind of take a look at the work within each of these areas. That can be kind of the methodology, but how do you want to handle reviewing this bulleted list altogether or break out into other subcommittees?
I think for me, it would be helpful to go through Stephen's list as a group. I think that list is very, very helpful because it breaks everything down, and we could do it methodically, but with discussion. I don't know how others
come
feel.
up with a similar list. Steve, I didn't take a good look at your list when it came to violence prevention. Did it have DV on there?
I think it did, but I'm going to do, give me a second. I'm going to set up my screen.
All right, I'm going to go ahead and.
It's got everything on it. Hold on. I'm going to try. So I've got a typed list that's mimicking the slide. And then let me open up that one. And just
I'm
so
going to go ahead and stop sharing so you can share, Stephen.
Thanks.
And if it's the specialization sort of material, we don't have specialization in every single one of these areas. We don't offer it necessarily.
Right. So let me do this to answer, I think, Sharon's request. Let me go. And so that I give a proper accreditation, one of our participants is Justin O'Connell, who is the legislation chair for FlexCom, and he's the one that directed me to this. So shout out to you, Justin. I know you can't say anything back. Okay, let's do my whole screen. If I share my whole screen, you guys don't see the boxes for, you see on the left a typewritten list and on the right the specialization list?
Yeah.
Yeah.
Okay.
Yes.
So let's go by. So the dissolution and parentage, that's just somebody getting a judgment, getting them divorced, getting them a paternity judgment when there's not a state agency involved or there's not a custody dispute. I don't think that that one's going to require a subgroup, but we can revisit it. There's nothing on the list of specialization that's going to come up. So subject area 3, this is entirely within division of assets and debt. So I'm going to go specialization, subject area 3.
And in terms of the question that's come up a few times about whether there would be an income delimitation, one of the things we can just pull is what other jurisdictions have set as that dollar value. So just.
Yeah, I don't think they
That
have.
would be helpful.
I think one has.
Did they? Okay.
Yeah.
It's not going to be an artificially, I'm not going to suggest, Lee, at any point that it should be an artificially low limit, but there is at some point when the state is so big, you need to tell the people, you need to have a lawyer to deal with this.
Yeah.
And what that number is, we can take into account the economics in the urban areas to make sure we're not getting people kicked out. And that's gonna be a subgroup discussion, I think, because you're gonna have to not just look at what the assets are, but also what's the debt. Because there's a lot of debt that could get saddled onto a person and as part of the settlement agreement, and then they can, very tricky things they can do by filing bankruptcy or sticking the other person with the debt.
Yeah, and it's also the nature of the asset. Like if you have a $5 million house and that's all you have, and you have debt that's a loan on the house, that's not nearly as complicated as stock options and all kinds of other types of assets.
I think subject area 4 would be a good idea to just talk about now, because it could lend itself to resolution now as opposed to going to subgroup. And my recommendation, and then I'll listen to others, is paraprofessionals should not be giving advice regarding tax issues related to sorry, got interrupted. Should not be giving tax advice, because like I said, most even the specialists won't give tax advice. We'll refer out to a tax attorney.
I totally agree with that. Is there a blankets crossover with estate planning issues? I know that, for example, if a property is owned in joint tenancy, that private attorneys, like one of the first steps is to sever the tenancy and so on. So there's some crossover issues there, but I'm not sure if that's mentioned in the specialization list.
Yeah.
I think
I could
that'll come up when we get into on the monetary limit, advising that, let me think about that. Let me just be quiet for a second then and listen to others. I'm not sure, Fariba.
I just want to throw an idea out there, that if we have a great list and all of this is very important, but the more maybe we can do this in 2 phases. I'm just thinking out loud, where we have maybe the top 3, and then for the first time that we create this curriculum, and then we leave other things for the future. Because my concern is that if we put too much and we try to create too much, then it would delay actually getting, the help out there. Again, just thinking out loud and seeing if we want to focus. And once we perfect the first pilot program, I believe that, elder abuse or other things will be easier to create and start again. Just a thought, do it in phases.
What are the ones you think should be delayed, Elizabeth?
Like I said, I believe elder abuse, that's one of them.
And then
And the CPS.
I had put that up here under custody visitation. The reason I would think I would maybe leave that in there, they changed the law 3 years ago, and every parent has a right to go request from CPS any report that pertains to the child. It gets redacted, and it kind of looks like, the joke documents they hold up in congressional hearings where all the stuff's been cut out. They take out the names. But I think that would be a really valuable service for a parent to get that advice from a paraprofessional that, by the way, you have a right to go request all the records from CPS.
I totally agree. And I also think a paraprofessional could teach them how to address this issue that the CPS got involved, and how to take the zing out of it, to how to neutralize the weapon, basically, and talk about it and explain it. I really think there's a lot of value, and it goes together with handling custody visitation issues, which to me is a no-brainer. Maybe we should come up with a list of no-brainers that paraprofessionals should do this, because I think that's easier than eliminating things that they should. Well, at both extremes, right? At the most difficult ones like tax issues, no-brainer, it should come out. And what is at the other extreme? That things that they should do, courses. Absolutely.
Yeah.
Maybe
I agree with you, Fariba. I'm also wondering if we can get a list from other states to see what specialties they included and what they did not include, and also dig in to see if it's worked and lessons learned, because we have the advantage of learning from other states. Like, we know that family law as a broad category is one of the highest needs in every jurisdiction. It's just a matter of like what's worked and what has not worked.
Yeah.
So we can get the information from Washington and Utah where it's been implemented and what they plan to do in Arizona. Minnesota just published some new rules. I think we put them in the Dropbox. So we can certainly do that. We'll certainly do that and bring it back to this group.
Right. Hey, Elizabeth, were there any of these categories on the left-hand side that you thought should be in the phase 2?
Other than elder abuse?
Yeah.
And CPS?
No, I think that looks good. I think the only thing for me was elder abuse.
Okay.
Can I ask you why you
For me, it was based on, I think, your conversation that you told us about how important it was, and how your guys are seeing an increase in elder abuse, and then people's property is being taken away, and it just sounded like something that the right person. I don't know that a 1-year class on elder abuse can really have a paraprofessional do this. That's just my thought, given the consequences. But again, I was just thinking out loud, and because you mentioned there was so much, maybe for that very reason we should move forward with it. But it just sounded like if there's so many issues, figuring that out, would that delay us getting people the help for the other, 50% of people that actually need help that don't have elder abuse issues. That's what was my thinking.
Oh, okay. No, I didn't mean that it was any more complicated than DVPA. I think DVPA has way more complications than elder abuse, and there's a lot of need out there for paraprofessionals to help these folks. So I would hope that we don't totally eliminate from this, but I appreciate that you recognize the complexities that could be involved.
Hey, Fariba.
Yeah.
I'm actually wondering, do you think if we have paraprofessionals offering services in DVPA, it's going to be disproportionately to the restrained party, not the protected party, because of all the public assistance that's available for the protected party?
That's a really great point, because we don't have any, we have all the advocacy agencies that provide services to the protected person, to the applicant. We at the courthouse are neutral. Obviously, we provide assistance to both sides, but you're absolutely correct that that may be their clientele, and there's a need. There's a need.
I did reach out to Aaron from the DVPA. So there's a group called the Domestic Violence Appellate Project that has been instrumental in basically writing domestic violence law. Their name is attached to pretty much about 15 of the most 20 important domestic violence cases in the last 5 years, where judges are just doing things that shouldn't be done and they go and fix it. So I reached out to her. She hasn't responded back yet, because I'd be curious to get her input about this. Kind of feeds into Elizabeth's argument. Maybe we take the abuse category and delay that, because it actually could be a public disservice for us to say paraprofessionals can provide services in DVPA, because what if the semi-wealthy but unable to hire a lawyer restrained party comes in with a paraprofessional, and I could see where this could be do a disservice to victims.
Well, I just want to be careful with that, because that's like saying to a public defender service is a disservice. Like, people do have the right to a fair education. Just because somebody files a restraining order doesn't mean always that it's 100% accurate. Or so I think part of our responsibility to ensure a fair system of justice would suggest that there should be representation for both sides.
No, I'm not. Yeah, I'm not suggesting otherwise. I guess what I'm saying is it will disproportionately benefit the restrained parties because of the services already provided to the victims, the alleged victims and the alleged restrained parties. I just want it to be considered.
So it's I believe we have another call on Monday, and I think, Sharon, you said you would like to go through, Stephen, this is the specialization skills as a group. Stephen, you indicated under topic 1, dissolution of parentage, there isn't anything here. If we start with topic 1, we'll need to kind of flesh out what those sub activities are. We could also start with topic 2 on our meeting on Monday. We could try to tackle 2 and 3 on Monday. If you want to tackle 1, we can also do some staff work between now and Monday to see what we can find in terms of a delineation of activities that would fall underneath that category. Any preference for what we focus on Monday?
You're saying under subject area 1 on the left side?
Yes. You want to start with subject area 1, we could try to tackle 1 and 2 on Monday. We could do 2 and 3, because 1 does not have that sort of, the legal specialization delineation of activities, which 2 and 3 does.
I think with the people we have on the phone call, I would say it may not require much discussion. And I just typed in, because what you're looking at is they're going to prepare the petition, the UCC-JEA declaration, and the summons. If there's, the latter 2 would be always in every paternity, or excuse me, the UCC-JEA declaration would be in every parentage case. it would not be a document in a dissolution without, where there's no children, and then helping people get the judgments done. And this is not to the exclusion of the other areas that fall within it, items 2, 3, and 4. This is just making clear that they can provide legal advice in the filing of the petition, the declaration, and the summons, and the filing of the judgment.
And don't forget responsive docs, and I would call it a non-issue judgment. Because you're pretty much talking about a judgment
So again,
with no other issues than the judgment itself, right?
Yeah.
And don't forget the service, serving people.
I got it.
Okay, so why don't we do this? Why don't we say Monday we will try to get through 1, 2, and 3. We may not. 1, it will be building out this list, making sure it's comprehensive. Staff will do some legwork in the interim, and Stephen will run it by you to try to get a fully comprehensive list. 2 and 3 will use the specialization framework. We'll try to get through those on Monday. Does that sound good to everyone?
I would suspect that might be overly ambitious.
I agree.
I think 2 is a meeting. I think 3 is a meeting. I think 4 could be combined with something because of the role of DCSS and the availability of the California support calculator. Maybe we talk about 1 and 4 next week.
And will we get this, your list, Steve?
Of course. So the two documents everybody sees on the screen, I'll convert the document on the left to a PDF, and I'll share both of these. What I'll do is, who do I send them to, Leah, to make sure they get out to everybody?
You can send them to Araya, and we'll get them into the Dropbox also. Send them out and get them into.
Okay.
Okay.
All right. Got it.
Thank you all.
Thank you.
All right, we'll see you next week.
Thank you.
Everybody.
Bye-bye.
Bye. Thank you.